I was crying. It happens sometimes. Um, I'm gonna do something. I'm gonna play an audio file I made before 5 o'clock p.m. today. I was out today. Tried to find something out. Whatever they think they're doing and getting away with. And every once in a while, this is how delusional I am. I actually believe that I had the right to try to go to court about crimes I had witnessed. And even though they told me they weren't going to give me a lawyer, they weren't going to give me an actual legitimate police report or a response from the FBI and or an acknowledgement from Congress or an acknowledgement from the Department of Justice when I showed up in person. I still was deluded into thinking that somehow I was going to go to court, right? That I was going to go to the Supreme Court, even, right? And I came up with a legal filing, which was actually the third attempt I made to go to the Supreme Court after going to a bunch of other courts. And, they say there's this lower standard for people to do pro se. Meh. I mean, have you read through some of these cases? I mean, have you actually read through some of the stuff that people think they're qualified to put before the Supreme Court? The lower district court? Really? Right? I really thought that, I was qualified somehow. You're not going to give me a lawyer? So what am I supposed to do? So I'm supposed to be doing what? Right? Besides whatever else I could be doing if you were giving me a lawyer? Why aren't you going to give me a lawyer? It's obvious there's crime involved. Obviously, crime involved. Why aren't you going to give me a lawyer? Okay, you want to see what I'll do if I represent myself pro se. Okay, all right. You want to see what you do if you humiliate me on the streets for years and you sell what I do. Okay. You want to see what I'll do if you take all my legal filings and make weapons out of them. Yeah. You know what happened with that? I made better weapons. Just so you know, I did. And then they stole them, and now they're testing them. It's a crazy thing, right? What's this? Oh yeah, this was my appeal. See, after what time was this? 4/12/2002. I was like, okay, this is due. If I was going to appeal this, there's a due date by which I would have to appeal it according to this code. So what code would I use? And then what would I say? I mean, I didn't actually send it in because, meanwhile, there's biological warfare going on. It might behoove somebody to actually respond appropriately. That jurisdiction thing, it's just a crock of shit. What's this thing right here? Here's the original petition. They actually sent me back the original, right? Now, my understanding is when you send it in paper, they make a photocopy. They copy everything that gets sent in. So, for instance, the first one I sent, I don't have a copy of it. Somebody intercepted it on the way back. But they have a copy of it. They have a copy of exactly what I said. First one, second one. They have a copy, right? I mean, unless somebody else is pretending they're the Supreme Court of the United States. But who would pretend that they're the Supreme Court of the United States? That sounds treasonous. You can't impersonate the Supreme Court of the United States. I mean, you could say, I'm submitting something to the Supreme Court of the United States. They won't give me legal representation. I'm just gonna go at it like I know what I'm doing. Go with God. This was the evidence, actually. This was the actual evidence of the charge. And the request was for articles of impeachment. Right? Printed out from the actual official congressional website. Actual website of it was actually a website for the House of Representatives because the Senate had just passed it and sent it to the House of Representatives. Don't worry, I'll show you the whole thing. It's like a scan. See? Got it here? Now, I did this thing when I got back from being outside, and I observed some things. I wrote myself an outline, handwritten outline, and then I did what would have been the argument for a voice file. I was going to put it on another site I have, but I'm going to do something a little different. I'm just going to listen to it, and I'm going to look through the bond booklet. Is this a blue sheet? It's not electronic, so it's a little different, right? I understand this is my bond on this case. You didn't give me a copy. This is an official rules of the Supreme Court of the United States. Now, I know what kind of scuzzy, disgusting underwriting you put on it. And I know what you tried to do for a recharacterization today. The problem is nobody contacted me. Nobody contacted me. And I know the scenario you're running on this bond with my case. So let me tell you what you're going to have to deal with this time, because that's a 10-year fucking bond. Really?
Else to try to acquire it as a sort of benchmark meeting on property they've already expropriated or stolen from me, or things they've already attempted to use in manners that not only have denigrated me or people with whom I was associated, but have been illegally expropriated under false pretenses and used under even more fraudulent pretenses in other efforts. This is part of what is an ongoing effort I have made to try to engage in good faith the judicial branch of government as a matter of redress. My name's Charity Colleen Crouse. I represent myself pro se at this time, although I have requested to be acknowledged as a member of the bar for the specific proceedings I have attempted to bring charges in regards to. Refusal to adequately address slavery at the onset of the United States, including in consideration of what constituted property for valuation and assessment regarding the domestic economy and into foreign commerce, persists to this day. This includes considerations regarding the original stock issues with the certificates for war goods that were used in the original minting of currency for the United States and in development of foreign relations. It also includes the beginning of the recommendations for and the implementation of the Bank of the United States, including the wealth of criticism and condemnation and caution that very prominent founders of the United States expressed at the time. And while it was not deemed to be unconstitutional through a judicial process, after the first charter of the Bank of the United States ended up expiring, it was not renewed at that time, and I believe that it demonstrates that there was just precedence for actually engaging it in a process to decommission it before it was allowed to reach the end of its term. It was obviously unconstitutional. However, refusal to address it as such and to bring exposure to the means by which it ended up not addressing the origins of slavery at the onset, including in manners that discussed what was available to be considered as property, including property for taxation, and also property in manners that specifically and intentionally dispossessed certain kinds of people of their concept of their own property by virtue of being ascribed as property to other people, are the primary issues that are still at the core of what we're dealing with today. In my attempts to to file with the Supreme Court of the United States in January of 2020, January 16th, 2020 specifically, the primary claim had to do with the concept that a mineral rights claim that was previously private property of individuals had been put into the public trust and then was allowed to be auctioned off by the federal government without explicating a specific process by which that is something that other people could be made aware of or participate in, and also without explication of the process of conveyance. That is just on the explicit merits of what was described, and without an understanding or proof at the time that that actual piece of legislation was being used as a form of derivative to describe processes by which other kinds of mineral rights claims or other kinds of things that would be considered property in the public trust meant for the people of the United States were allowed to be misappropriated in order to be auctioned off by the government, and also were allowed to be mischaracterized in terms of the means by which that public property was put into trust or which the trust was characterized as being for the public, which includes illegal expropriation, potential illegal expropriation of people's private personal property. And this was the major argument because for several years, for 2 years up until that point, I'd been attempting to contact, including on the Supreme Court level, people to address the fact that there was a criminal conspiracy responsible for illegal expropriation of people's personal private property in order to obligate it to fraudulently determine and fraudulently characterize public debt, including federal debt, based on the fact that there was misrepresentation of the terms of the definition of that debt, and also that there was not an adequate explication of the difference between debt and obligation, especially debt and obligation in consideration of participation in a federal capital outlay process, as expressed through the federal appropriations process. The major concern had to do with intangible property rights of individuals explicitly and implicitly, how it has to do with concepts of intellectual property, what has happened with protections regarding privacy and intellectual property in the years during which this criminal conspiracy was gaining its primary power and its primary momentum. And also the concept of the basis of participation in an economy via valuations of property and also characterizations of property, including who that property belongs to. Congress has a power but also a duty to tax and spend, so the constitutional issues of taxation and appropriations are very much the concern. Laws regarding accounting for and appropriation through the federal budgeting process need to be considered accordingly. And this was at the core of my original efforts to try to get someone to address what was an appearance of a pattern of racketeering evidenced through the federal budget process that was not exclusive to the federal budget process, but rather appeared to be able to accrue because specific benchmarks and specific refusal to honestly and legally address the federal budget process had allowed for their propagation in other levels, and over time had allowed for a kind of leveraging of the default that came with mischaracterization and refusal to actually adhere to appropriate accounting for obligations incurred through the federal budget process, had allowed for that pattern to be demonstrable through the more recent and the federal budget processes for 2018, 2019, and now 2020.